item number.
The reference order that
This
clearly
is-
captures the facts also. So it will
Reference
while
order.
the
2009-10.
9, 10. 9 selection is of 9.
Lord,
And for translators, who
Lordship, I will just explain if my friend he allows.
501.501.
501.
501
1
and 501.2, Lordship, I am appearing for.
501. 1 point?
Tarun Kumar and Tej Prakash.
All three, the first three.
501.9, yes.
Lordship, I have no idea about the third one, but yes, I am appearing in two matters, Lordship.
501 and 501.9.
9 and 10.
She is appearing on 501.9.
1 and 9 I am appearing, Lordship.
Mukesh and Jain is same.
Same.
Same
Same
is
selection.
there, Lordship.
All same.
And what about, all right.
Only three matters are there, Lordship.
Right. Now tell us what the facts are.
Lordship, the notification, it had come in 17/9/2009.
17?
9/2009. And exam date was 19/12/2009.
What is the notification for holding the exam for?
Lordship,
For translators.
it was for employees who were actually working as a judicial clerks, UDC, in Rajasthan High Court. They were already in services, Lordship. And this notification for those employees who are already in the job and just to shift, promoting to the
This was
translator.
for in-service employees.
Service employee. Lordship, 21 eligible of employees were appeared in the test held on 19/12/2009. There were 13 vacant posts of translators which was issued on 17/9/2009. Applicants applied as per eligible qualification which was possessed by them, which was only MA in English, Lordship.
What there was Mumbai. 24/7/2.
Can I read notification
Go ahead.
of
Just tell us,
2009?
give us the date. Give us the dates.
Lordship,
After the
dates is
advertisement, what
fine,
happened?
still I want to go.
That's the most important thing. Just tell us the dates and we'll go to the law.
2009 that I have already
24.
17/9/2009, which was a notification, which was actually the Rajasthan High Court Staff Service. Applicants were invited for given performer for the recruitment of 13 vacant
Right,
posts
you told us. And 21 appeared on 19/12/2009.
Lordship.
Then
And Lordship, then the result was declared
on
on 22/2010.
22/2010.
Lordship. Lordship, till now we were not aware that the rules were changed one day before 19/2/2010, which we came to know actually when once we filed writ petition before the High Court, and there when the counter affidavit was filed by the respondent,
19th
it was
February. 19th, your results were declared on
19th
20th.
February 2010, the
19th,
notification.
they have imposed the 75%.
75%, Lordship, which was not even there, the
Right,
minimum
right,
and
right,
maximum, nothing was explained. It was for translators, which was actually to Hindi to English and English to Hindi. That was the only test prescribed in the 2009 notification.
These post what?
Kept vacant, only 3 were taken. Lordship, the employees who were actually, they had appeared in these examinations, which were my petitioner. We all are petitioners. They had scored 71%, 69%, 68%, 68%, 66%, Lordship.
How much? 71%?
71%, 69%, 68%, 68%, 66%, 57%.
Below 75.
Lordship. And Lordship, these were the marks which were actually they got, which they were not even informed. Even till when I filed my writ petition, I was not aware. When I
So
filed
your
my
contention is
RTI,
now those who have been selected,
Lordship,
those who, and was there a Viva here?
Lordship.
There was a Viva here or no?
No, Lordship. It was only written examination.
Only written exam.
Because it was for
But you were
translators.
75% minimum.
Lordship,
But
that's
those who
what
were
we want
selected,
to-
those who were selected, all got 3 people who were selected got more than 75%.
They got Lordship.
And 10 persons
Lordship.
who were not selected at all
Lordship.
were all below 75%.
75%.
Were they,
One got
were they bound to fill up all the
75% of-
posts? Were they bound to fill up all the posts?
Lordship, what I am saying, had I been knowing that I have to prepare in such a manner that it is a competitive examination, I would have
You
prepared.
are starting from the stage of preparation.
Lordship,
No.
this is against Article 14, Lordship. I am not
It is
given a
not
chance.
14 does that apply.
Don't even
They were
go.
not bound to fill up all the posts.
No,
So forget the fact that they laid down the 75% criteria later. They were not bound to fill up all the posts. They said we'll take the first 3.
Lordship, may I read the reference
Not a case of
order?
a change of the rules of the game in that sense. You see.
Lordship. And Lordship, I want to
You
read.
see, in the earlier case, for instance, the Kerala case, what happened was,
Lordship.
yesterday, which we heard, because of the fact that there was a change in the rules of the game, then though these people who were excluded, they had higher marks in the aggregate, they were still not selected because they didn't get the minimum marks in the interview.
Lordship, in my
That is the problem.
Lordship.
Here, all of you are anyway below 75%.
The merit list, they just stopped
Yes.
at one particular
Only
post.
one line. There's in the other cases there was a revision in the merit list because of the change. There's no revision of merit list. It is still the same. Top 3, top 5, 75%, above 5. That is how it has been done in this case. So
Lordship.
there's no change in the merit list in terms of preparation.
No, there
So
was
that is what.
No.
In all other cases, there would be a change in the merit list because of that introduction of qualifying marks. That is the
Lordship,
distinction.
I want to submit, Lordship.
It was very straightforward. Speak of the
Lordship, 2002 rules I have filed, Lordship, and I have given the copy also. Lordship, earlier it was 75% only, and why? Lordship, it is,
pertains to
Lordship,
selection
Lordship, it is very important. I have
conducted
waited
by
for so long.
the
Just one
Rajasthan
minute.
High Court
I am heard.
in 2009,
We have seen that.
2009-10 for appointment of translators.
Lordship, may I read one reference order? Lordship, this much chance
Yes,
I should get,
Dr.
Lordship.
Bhardwaj, you have read the reference order, but the point of the matter is this.
Lordship.
Your case is that after the examination was held,
Lordship.
they decided to have a cutoff of 75%, and therefore there's a change in the rules
Lordship.
of the game. And
Which was
therefore,
earlier again 75% in 2002, and again they had come and changed in
Right.
2009.
there was no
Lordship.
cutoff.
No cutoff.
There was no cutoff
Lordship.
when the advertisement was issued. Now, what they did was they applied a cutoff of 75.
Lordship.
All right, they took the first 3 candidates and then didn't fill up all the 13 posts. They just filled up 3 posts and didn't fill up the remaining 10 posts. There are 2 others. The basic answer to that they are not bound to appoint everybody at all.
Yes.
Second, you see, what we try to tell you as a difference, possibly you didn't realize that because you were not here in that matter yesterday. In the Kerala matter which we dealt with yesterday, they decided, the rules provided that the selection will be made on the aggregate marks in the written examination and the interview. These petitioners who were before us yesterday said that you applied a cutoff for the interview.
Yes.
So though we had higher marks than the selected candidates in the aggregate of the written plus the interview, we have been excluded only on the basis of the fact that we did not score the minimum marks in the interview, which requirement came in later. So there was a revision of the merit list. Here, all that has happened is that they said, look, we will not take anybody who has less than 75% marks.
Now, Lordship, what
I could
happened?
have said
In
top
next
3
year,
also. I
Lordship,
could have said top 3
next-
also. Instead of saying 75, I could have said
Then
top.
what happened? Next year again they took the exam. They kept 75%. Nobody cleared the exam. 0. Nobody was taken.
That is what the
And then
translator is an important post for us.
to
We have the judgment where to be
that no
translated.
one-
There are so many
nobody
things to be
facts-
translated.
Council will take
Dr.
everything.
Bhardwaj, this touches the first point that you made,
Lordship,
that you will have to prepare harder.
Lordship,
This is the first point that you made.
Lordship.
That's why.
Lordship, it is just the thing that now why did they come now? Again, the minimum maximum, there is nothing. You can come again because they did not get on 75%. That was the only year.
It's not all in-house
If
candidates.
that was the only year when that means only my batch I am suffering, nobody else. My next batch is lesser than me and still they are on the post, Lordship. Test of arbitrariness, Lordship.
the selection was for in-service candidates. Full stop. Uh, the notification for the examination was issued on 17 September 2009 for a total of 13 posts. Full stop. 21 candidates appeared at the examination on 19 December 2009. Full stop. The result was declared on 20 December 2010. Full stop. The grievance of Dr. Ritu Bharadwaj, Learned Counsel appearing on behalf of the petitioners, is that initially on 24 July 2004, the cutoff which had earlier been prescribed in the written examination had been removed, as a consequence of which, on the date of the advertisement, there was no prevailing cutoff for the written test. Full stop. Learned Counsel submitted that on 19 February 2010, one day prior to the declaration of the result, the High Court decided to impose a cutoff of 75% marks in the written test. Full stop. This, it has been submitted, is arbitrary, since it would amount to a change in the rules of the game midstream. Full stop. On the other hand, the submission of the High Court is that, as a matter of fact, is that the High Court decided to take only 3 candidates who had more than 75% marks, having regard to the fact that translators were being appointed into translators were being appointed. Full stop. Next. It is a settled principle of law that the authority which notifies a selection process is not liable, is not bound to fill up all posts. Full stop. However, it is equally well settled that such a decision must stand the test of fair procedure, of fairness. It's not a case where candidates who were otherwise eligible for being considered were excluded as a result of the application of a new rule midstream during the course of the selection process. Full stop. The High Court was not bound to fill up all the posts which were notified for selection and decided to fill up only 3 posts, having regard to the necessity of appointing persons of the requisite merit as translators. Full stop. In the circumstances, the High Court eventually decided to fill up only 3 posts, leaving 10 unfilled in the selection of 2009-10. Full stop. These were again appointed only on the basis of merit, and the petitioners rank below them in the order of merit. Full stop. Vote rejected. Yeah. Rejection of the petitions under Article 226 of the Constitution by the High Court has led to the institution, has led to the invocation of the jurisdiction under Article 136 of the Constitution. Full stop. For the reasons which have been indicated above, we find no merit in the petitions. The petitions shall accordingly stand dismissed. The reference to the Constitution bench shall accordingly stand
Lordship,
answered.
may I submit now, Lordship, one more thing, Lordship. We were not at all here for the merit of the candidates, Lordship. We had to decide one main important question.
As I follow, the reference to the Constitution bench does not arise in the facts and circumstances noted above.
Lordship, may I submit now, Lordship? I maybe heard only one point, Lordship.
Yes.
Here we were discussing about whatever rules are made at the last time when the selection process has already started. This point had to be decided by the Constitution bench, Lordship.
All right, ma'am, I'll tell you one more reason.
Lordship.
Suppose they had not altered
Lordship.
that. Suppose on the 19th of February they imposed the bar of 75%.
Lordship.
Suppose they had not done that.
Lordship.
Were they still bound to appoint you? No.
Lordship, I am not at all talking about my appointment. I am talking is, Lordship, what now Lordship says today. It will be followed in all
Suppose-
the exams.
no.
We will not be
No,
told any syllabus and suddenly
No,
there will
no.
be any change at any
Suppose,
time.
ma'am, ma'am, suppose we ignore the decision which the High Court took on the 19th of February to have a minimum requirement of 75% in the written exam.
Lordship.
And suppose there was no minimum requirement of 75%.
Lordship.
All of you had therefore qualified. Even so, the High Court could have said, we are taking just the first three candidates who have above 75%. That's the difficulty in your case.
Lordship.
They can always say that we don't want people who have, say, got 57 marks out of 100 in the exam.
Go to 47 if 13 were to select.
The rule can be set up by the Honorable High Court or Supreme Court, Lordship, but we should be informed in time. I am just asking about that point, Lordship, what we had to discuss today in this Constitution bench, not the merits, Lordship. We are not talking about whether I should be taken on this post or not. I am talking whether such rules should be.
We should be very careful about answering questions in the abstract.
Yes.
We should be very careful about answering questions in the abstract.
That's why, Lordship, I requested to read referral judgment, Lordship.
Read that.
9, 10th, 11th, 12th, Lordship, if you will see, there he himself, Lordship, he clarifies that this is wrong when arbitrary.
That will arise in a case where there is a right of appointment, but there is a violation of that right arbitrarily. In your case, the right of appointment doesn't arise
Right
because
of appointment to Lordship. Making of the rules when the selection of process is started, Lordship, it is the point, not the.
Now we are left with 501.8, which is National Council
Lordship,
for
there are
Education
12 of
Research and
Manjushri,
Training.
he is very clear about it,
All
Lordship.
right. Ma'am, sometimes you have a law of this court which is holding the field from 74. Then you have a judgment of 2008. Let benches consider those cases on the facts of each case. Sometimes it's better not to, lay down these very rigid rules in a constitution bench.
In fact,
both
both
are
are different
Lordship,
aspects.
but bigger issue
particularly
was
in service
before
matters,
the-
always
Lordship.
wise to look at the facts of a case and then take a decision, because you can adjust the equities.
so upon 501.9 and 10, are they different?
No,
No,
same
Lordship.
selection. Same
They
selection.
all are same.
501,
Without-
501.9 and 10 में ये order आ जाएगा.
Yeah.
अच्छा, now 501.8.
Lordship, this is regarding conducting of examination, that is National Talent Search Examination conducted by the NCRT, Lordship. All India examination, selecting candidates on the basis of their merit to grant scholarship.
Can we have your name, please, counsel?
Lordship.
Your name?
Ashok Kumar Panigrahi, Lordship.
Yes.
ये मैटर होने के बाद and before we take up the yes.
Lordship, initially when the examination was, for the examination, the advertisement and the further process was on,
This is for a scholarship, is it?
false scholarship. It was initially that there are two parts of the test, that is mental ability test, then there is a scholastic aptitude test. In the scholarship aptitude set, there are two categories. One is language test, the other one is subjective test, that is science, mathematics, and social sciences, irrespective of the, as per the choice of the candidate, whether they are choosing science or social science or mathematics. Lordship, initially it was the issue that the language score will also be considered for the purpose of calculating the total merit of the candidates to judge their performance in the examination.
Language score also.
Language score, that is English. During the process, when the examination is on, there are several complaints received from various corners of the country that the English language, because most of the candidates are from rural background, they are not much conversant with the English, so English should not be made as a deciding factor to deciding the final merit of the candidate. Rather, it should be made qualifying. So this matter was referred to a committee. Committee duly considered the issue and decided that let the English be considered as a qualified, not the merit deciding factor.
Yes.
But the issue is that this was done when the examination was on. That means the already candidates are already applied and they already appeared in the one part of the examination. The other part was to be followed. So during the process, this decision was taken to make the English qualifying.
Qualifying.
But there are certain candidates, those who have scored very well in English, they made a complaint. So after declaration of the result,
He's saying
that look, if our English mark would have been considered, we would have.
now where does your candidate client fall?
I'm for the institution lordship. I'm
Oh.
not for the candidates. Because the Rajasthan High Court has allowed this petition relying on the judgment of K. Manjushri and this Samarjit, which is on
Now
draft.
tell us one thing. Oh, I see. Now, therefore, the committee said that English should be treated as a qualifying mark and not for merit.
Lordship.
Some candidates who had scored high in English said that you can't.
No, they went to read. They went to read High Court Rajasthan. The Rajasthan High Court has ruled in their favor, stating that, look, you cannot make this rule during this process because the rule of the examination cannot be changed, relying on the judgment which is under reference lordship.
Now, what happened? Were the scholarships given to those then the
No, the
petitioners?
problem is lordship.
What happened then?
My result was the result came after my declaration of result.
Then
I decided the result making English as qualifying. There are two candidates. The order went in their favor. Let the English be considered to calculate the final result.
how many candidates?
Two candidates, two petitioners here
In the High Court, two petitioners. in the
before the Rajasthan High Court, lordship.
So eventually, did they get the scholarship or no?
No, so far because this order is under stay, lordship. Because my problem as on date
How
is
much was the scholarship?
it is some 1,000 lordship per month.
For how many months?
It is, if the candidates are performing well, it will continue till their post-graduation study, completion of their post-graduation.
And who is appearing for them?
Candidates, they have not given appearance, any appearance from there.
Nobody's appearing.
No, there is no candidates.
They would have finished. They would have finished and lost interest. They must be now.
They lost interest. In fact,
They
they
must
lost
be now
interest.
somewhere in service. Now, should we decide it on this?
Lordship, my problem
2017.
is that I have to review the entire result.
2017. This was
Entire result cannot be reviewed because
2013.
there are n number of candidates who has.
This is National Talent Search Examination
Examination.
2013 or when it was? When was
Yes, 2013, Lordship.
advertisement of 2013?
There are
Repetition
n number of
by
beneficiaries
Professor.
who has enjoyed the benefits. And if I recalculate it again on the principle that considering the English language, the entire result may be completely changed. So this is the case, Lordship.
Scholarship, They would have etc. finished
Oh, yes,
PhD
everything.
and
This order came even after declaration of my result, Lordship.
And you gave the scholarship to those students. There were fixed scholarships, fixed number of scholarships?
There are a fixed number of scholarships. There are, I think, 1,000 some odd candidate based on merit. It will be given to entire country.
So those candidates have already ended.
Already,
This
already,
stage now is in question.
That is why these two candidates lost their interest and they didn't appear, given their appearance before this.
Matter here, I think. We'll
Lots-
set aside the judgment of the High Court, I think. You know? There's nothing. We'll say survives. Yes. Haripya?
The problem is today, the Tej Prakash reference says that Manjushri has not taken into account Subhash Marwaha. So while your lordship is not addressed that issue in
It
this
has not
judgment.
arisen in any case.
Yes,
So
then your
therefore in the
lordship will just
previous
clarify
order.
that Manjushri will hold the field because it's 3 judges and Marwaha has 2 judges. Because when it eventually goes back, we will come back to this dispute whether Manjushri is.
But that anyway held the field, right? Because it's a larger bench.
Holding the field, but the view taken by the reference order in Tej Prakash is that Manjushri was passed without reference to Marwaha. and therefore Manjushri has to be reconsidered. So today the problem will arise when matters go before individual benches, whether Manjushri should be followed at all. But it's 3 judges. Marwa has 2 judges.
And just one more sentence, my lord, like in this example.
But they can release, the earlier judgment is 3 judges, no?
No, 2 judges. Marwa has
Marwa has 2.
Manjushri is 3.
Not also direct.
The Lordships is right, these issues may not arise in these petitions, but that doubt is now cast.
Because my lord, in Manjushri para 12, in my learned friends, Mr. Bharadwaj's contention, Manjushri says, suppose there is no minimum cutoff, there are 13 people, you are bound to take the 13 best people. So you can't fix the cutoff. So that is what para 12 of Manjushri says. So if Manjushri has been applied in her case, she had a right to get the 13 people, first 13, had a right to get appointed. Now, because they introduced the 75%, people below 75% went off, which is why Tej Prakash
But
says.
you know, then what would happen is that if you are bound to take the 13,
Yes, my lord.
even if the 13th has got 40% marks, you're bound to appoint him as a translator.
But that is
That's
subject to.
a practical difficulty. Absolutely, I understand. But in the future situations may arise where people who have got 74, 73, 72, they won't take the 13 because they say we have fixed a cutoff of 75%, which came after the results. So if you strictly apply para 12, factually Lordship is right because there was no minimum. So somebody gets 1 mark, 2 marks, 3 marks, they may have to be taken. I understand that.
Also-
But law.
And if I
The
may
point
say,
is, where do
It
we
will arise somewhere.
in a given case? It doesn't arise in these cases
may I
really.
speak
You know.
one more submission, Your Lordship? No, in Tej
No,
Prakash.
what
if-
could be done is when the matter, we have now referred to two regular benches.
Yes.
So this could be thrashed out before the same two-judge bench and let them apply their mind on the facts and overall perspective. Then the matter will come for reference to
My only may I just make one submission? The Tej Prakash was passed by 3 judges, the reference order. Now, 3 judges have said that Manjushri has not taken into account Marwaha, which is 2 judges. And one more small submission. And it will be in Tej Prakash. And the reason, Your Lordship, is this, may I just make one more submission? Tej Prakash proceeds on the
case
basis.
that doesn't arise.
It doesn't arise.
It is saying that.
Because then we will have to say that they are duty bound to take all the 13, irrespective of the marks. which you say.
Precisely. I agree with the Lordship.
Which is that you have to issue a mandamus that you must select everybody.
Mandate that.
Law doesn't mandate it.
Para 12 of Tej Prakash has misread Manjushri in my opinion, and they said if Manjushri was to be strictly applied, all candidates have to be taken, whereas Marwaha is contrary. In my opinion, para 12 itself is not correct. Manjushri does not say that specifically at all. So para 12 and 13 of the Tej Prakash reference order, if Your Lordship will read, that now is also by 3 judges. Now, today the situation will be, will everybody follow Tej Prakash's reference order which says Manjushri is not correct, or Manjushri which Tej Prakash is wrongly interpreted?
But the subsequent judgment is of 3 judges, right?
It's not a judgment, it's a reference order.
No.
Manjushri.
Manjushri.
Manjushri is
3 judges.
Now, you can't doubt as a matter of first principle, you cannot doubt a 3-judge bench judgment on the ground that it has not referred to a 2-judge bench.
3 judges have doubted it in Tej Prakash.
Right, but I think that doubt itself is wrong.
Then Your Lordship may have to clarify.
Unless we say that the 3-judge bench which decided the subsequent case is independently not correct law, then you can certainly look at it.
They'll have to see whether they will have to see whether Tej Prakash has rightly understood Manjushri, Your Lordships.
Explanation.
They will have to see if Tej Prakash has rightly understood Manjushri.
Lords, I have, my lords, it's in fact, my lords,
Because Manjushri does not say everybody has to be on that list. Specifically,
Yes.
there is no such
All right,
issue.
we can do this. We can see the referring order in Tej Prakash.
We will clarify.
All right, in 5, and we'll just clarify it in 2 paragraphs so that, we are then done with it.
may make
Because
one
otherwise
submission, my
that will be
lord.
left out.
In fact, Manjushri was cited subsequently in many cases before this honorable court. And especially, my lord Justice, Honorable Justice Tigesh Roy was also part of particular case from Goa, my lords, was that facts of the Manjushri case, and this is totally different. Manjushri is not applicable. That was also a change of rules after the game is played. In fact, many cases, though Manjushri was cited and tried to link it or tag it along with the constitutional bench. This honorable court rejected that and said that it has to be decided in its backside. And whereas
Yeah, that's right.
That's right.
Tej Prakash as well as Marwa, there is no case of cut-off marks in the interview.
Yes, so those
There was no-
line of Manjushri and line of Marwa is different.
I'll just.
This has nothing to do with Tej Prakash,
Yes,
it's
no.
totally different.
May I
There's no
submit-
conflict is a,
Okay, we will.
All right, let's do this. Let us do this. If it comes to it, let us see the referral order and the two judgments. That's all. It'll take us 10 minutes to see that. All right.
Lordship, in my case, the only problem is that post 2013, I'm conducting the examination, making English, making,
This matter we'll close because your matter now doesn't, this has become infructuous really.
no, Lordship, the reason is
They're
that,
in your favor.
no, that is all right, but with respect to conducting the examination, because the largest, single judge has allowed this petition relying on K. Manjushri. That was affirmed by the division bench. I am before your Lordship. Candidates has not marked their appearance, I think they lose their interest.
But there is no law which has been laid down in this matter, in the facts and circumstances of the case, because the candidate respondents are also, it's for grant of scholarships.
Yes,
For
Lord.
1 year period.
No.
Ah.
It is starting from +2 to postgraduate. Based on the
That would have
continuous performance, if they are
2017.
performing well, they will entitled to have the scholarship till post-graduation. But only my problem is that post 2013, after this examination, I continue with this standard that English would be qualifying only. At this stage, now tinkering with that principle of making English as an aggregate, as the High Court has ruled in their favor, will also upset the entire process, Lordship.
Do is in a minute, we will close this case and we'll just come back to Dr. Bharadwaj's case and you can just assist us for 10 minutes on Dr. Bharadwaj's case. We'll see if any conclusion may ultimately be the same, but if we have to just clarify the law in 2 paragraphs, we'll do that.
I'm ready.
Just say this. In 2013,
Lordship, my point is that they didn't qualify in the result. They only relying on the judgment of the High Court based on which they are qualified. Otherwise, result is not in their favor.
Oh, they lost. They didn't pass, you mean to say?
This High Court has said, consider his English language and grant them, they are qualified.
but
That is the-
no, but if the English language marks were considered, they would have qualified, right?
Yes, that is the case.
That's the one.
That's the-
Then it's a.
In 2013,
That means in the entire result would be reviewed again.
NCERT issued an advertisement seeking applications from candidates for the National Talent Search Examination. Stop. During the course of the examination, candidates were subjected to 2 objective type tests, namely, bracket 1, mental ability test, semicolon, and bracket 2, scholastic aptitude test. Good stop. The first and second respondents were students at the class 10 stage applied for the NTSE.
NTSC.
Full stop. Provisional results were declared. Full stop. A decision was taken to the effect that the marks secured in the language test, into bracket English, right?
English.
In the English language test,
English, English.
would be treated only for the purpose of qualification. Full stop. The first and second respondents did not qualify at the examination. Full stop. However, they obtained information under the Right to Information Act, in pursuance of which they were intimated that the marks which were scored in the language test were not taken into account in the final selection. Stop. They instituted a writ petition before the Rajasthan High Court. Stop. Their contention was that they were aggrieved by the decision to treat the language test only for the purpose of qualification, as distinguished from merit.
Account for the
Only Kavlika, they were aggrieved by the language test being treated only as a qualifying test, and not for computing the merit, the aggregate marks in the preparation of the merit list. Full stop. It appears during the course of the submissions of the petitioners that the decision to treat the language test only for qualification was taken by a high-powered committee, which acted upon
That's the only committee, not
high-powered by a committee,
by a committee.
following representations which were received from students, particularly with a rural background, particularly on the basis of representations received from students that
Students, the guardian,
parents,
not because students are minor.
representations are received on behalf of students to the effect that treating the language test of English for the purpose of computing the merit list would cause serious prejudice to students, particularly from a rural background. Full stop. The single judge of the High Court allowed the petition under Article 226 and directed the petitioners to determine the merit of the first and second respondents afresh after considering the marks which were scored in the language test. Full stop. This decision was taken on the basis of the judgment of this court in K. Manjushri versus State of Andhra Pradesh, 2008, 3 SCC 512. Full stop. The writ appeal was dismissed by the division bench. Full stop. While on 12 February 2018, notice was issued in these proceedings under Article 136 of the Constitution, and the contempt proceedings which were initiated before the High Court were stayed. Full stop. क्या किया होगा? Hearing the proceedings have been tagged together with Civil Appeal 2634 of 2013. 2634 is that, yes, into brackets, Tej Prakash Pathak versus Rajasthan High Court,
That is the main petition.
in which a reference has been made to the Constitution bench on the basic issue as to whether the rules of the game can be changed midway after the selection process has been initiated. Full stop. In the present case, despite service, none has appeared on behalf of the first and second respondents. Full stop. We are not inclined to go into the broader question which was raised on the reference to the Constitution bench and the facts of the present case. Full stop. The judgment of the single judge would result, learned counsel appearing on behalf of the petitioner submitted that the judgment of the learned single judge would result in a situation where the entire result would have to be redone, since a conscious decision was taken in the interest of the students not to treat the language test as a merit-based test, but only for the purpose of qualification. Full stop. If the judgment of the single judge were to be upheld, as has been done by the division bench, the result would have to be recast at this point in time, nearly 8 years after the examination has been concluded. In the meantime, following the declaration of the results, the National Talent Search, that the scholarship following the National Talent Search examination has already been awarded to a large number of students situated all over the country. Full stop. In this backdrop, and without this court expressing any opinion on the broader question of law which was sought to be raised, we are of the considered opinion that it would be appropriate to set aside the interim judgment of the High Court, which we accordingly do. Full stop. The petition likhana humne, the appeal shall be granted. The appeal shall stand disposed of in the above terms. All right, now let us see Tej Prakash Pathak. Where is the judgment? Just show us from the compilation.
But it's
It's on page number
Vijay, I'm sorry.
210.
if your lordship can see in
compilation.
the Mr. Hansaria's volume 1 compilation, that would be at PDF page 212,
Volume 1, right?
volume 1.
Volume 1, 212.
PDF page 212.
All right. Yes.
Lordship, please come to para number 10, first 10.
Distinction.
Under the scheme of our constitution, an absolute and non-negotiable prohibition against retrospective lawmaking is made only with reference to the creation of crimes. Any other legal right or obligation would be created, altered, or extinguished retrospectively by the sovereign lawmaking bodies.
Just a minute, PDF page, give me the page again.
To PDF 212 starts.
All right,
He's reading at 216.
all right.
Right, running page 214.
214.
PDF page 216.
However, such drastic power is
Wait a minute.
para 10. However, such drastic power is required to be exercised
Higher law.
Para 10, no?
Para 10. The scheme of our constitution, an absolute and non-negotiable provision against retrospective lawmaking is made only with reference to the creation of crimes. Any other legal right or obligation could be created, altered, extinguished retrospectively by the sovereign lawmaker. However, such drastic power is required to be exercised in a manner that it does not conflict with any other constitutionally guaranteed rights such as Article 14 and 16, etc. Changing the rule of game, either midstream or after the game is played, is an aspect of retrospective lawmaking power. Various cases deal with the situation where the state sought to alter the eligibility criteria of the candidate seeking employment or the method and manner of making selection of the suitable candidate. The latter could be termed as a procedure adopted for the selection, such as prescribing minimum cutoff marks to be secured by the candidates, either in the written examination or viva voce, Mr. Dunning Manjushri, or the present case of calling upon the candidates to undergo some tests relevant to the nature of the employment, such as driving test abroad. If the principle of Manjushri case is applied strictly to the present case, the respondent High Court is bound to recruit 13 of the best candidates out of 21 who applied irrespective of their performance in the examination held. In such cases, theoretically, it is possible that candidates securing very low marks but higher than some other competing candidates may have to be appointed. In our opinion, application of the principle as laid down in Manjushri case without any further scrutiny would not be in the larger public interest, or the goal be establishing an efficient administrative machinery. This court in state of Haryana and Subhash Chandra Marwa, while dealing with the recruitment of subordinate judges of the Punjab Civil Services, had to deal with the situation where the relevant rule prescribed minimum qualifying marks. The recruitment was for filling up of 15 vacancies, 40 candidates secured the minimum qualifying marks, 45%. Only 7 candidates who secured 55% and above marks were appointed, and the remaining vacancies were kept unfilled. The decision of the state government not to fill up remaining vacancies in spite of availability of candidates who secured the minimum qualifying marks was challenged. The state government defended its decision not to fill up posts on the ground that the decision was taken to maintain the high standards of competence in judicial service. The High Court upheld the challenge and issued a mandamus. In appeal, this court reversed and opined that the candidates securing minimum qualifying marks at an examination held for the purpose of recruitment into the service of the state have no legal right to be appointed. In the context it was held. In a case where appointments are made by selection from a number of eligible candidates, it is open to the government with a view to maintain high standards of competence to fix a score which is much higher than one required for more eligibility. Unfortunately, the decision in Subhash Chandra Marwa does not appear to have been brought to the notice of the lordships in Manjushri. This court in Manjushri relied upon P.K. Ramchandra Iyer and versus Union of India, Umesh Chandra Shukla versus Union of India, and Durga Charan Mishra versus State of Orissa. In none of the cases was a decision in Subhash Chandra Marwa considered. No doubt it is salutary principle not to permit the state or its instrumentalities to tinker with the rules of the game. Insofar as the prescription of eligibility criteria is concerned, as was done in Channa Swami versus State of Mysore, Channa Vasavaiya versus State of Mysore, etc., in order to avoid manipulation of the recruitment process and its result. Whether such a principle should be applied in the context of the rules of the game, stipulating the procedure for the selection, more particularly when the change sought is to impose a more rigorous scrutiny for selection, requires an authoritative pronouncement of a larger bench of this court. We therefore order that the matter be placed before the Honorable Chief Justice of India for appropriate orders in this regard.
Yes.
Lordship, now the para number 27, also I want to read from Manjushri.
All right. What page is Manjushri in
Yes,
this compilation?
167 of the same compilation.
How much?
167 PDF page 167.
167.
167, para number 27.
Starts at 160.
But what could not have been
We
done?
see Marwa before that, or you want to see? Oh, well, right. We see Manjushri, and then we'll.
First Manjushri, Lordship. But what could not have been, para 27. Lordship.
1 second. Let's see the facts of Manjushri for a second.
Para 2, Lordship.
Yes.
Para 2, Lordship. Selection and appointments to the post of district and session judge are governed by the Andhra Pradesh State Higher Judicial Services Rule 1958. The said rules provide that 1/3 of the total number of permanent posts of district and session judge should be filled by direct recruitment. It also prescribes the qualifications for appointment but does not prescribe any procedure for selection. As the rules only prescribe the qualification for appointment but did not lay down the selection procedure. The manner and method of selection is decided by the High Court. For every selection, as and when the vacancies are notified for selection, the government of Andhra Pradesh has issued an advertisement dated 28/5/2004 inviting applications for appointment to the following 10 posts of district and session judge. Now, Lordship, para number 4. The full court of Andhra Pradesh High Court has authorized its Chief Justice to constitute committees for the convenience of administration. The resolution of the full court containing the guidelines relating to the functioning of the High Court have been compiled in the form of standing orders. 2.13 enumerates the matters to be dealt by the full court. SO 2.14 enumerates the matter to be dealt with the administrative committee. Recruitment of district judges is a matter to be dealt by the administrative committee under SO 2.14. The decision minutes of the administrative committee in regard to the recruitment of district judges are therefore placed before the full court for its consideration under SO 2.13. The administrative committee, by its resolution dated 30/11/2004, decided the method and manner of selection. It resolved to conduct the written examination for the candidates for 75 marks and oral examination for 25 marks. It also resolved that the minimum qualifying marks for the OC, BC, SC and ST candidates shall be prescribed earlier. As per its direction, the written examination was held on 31/2005 and 1026 candidates appeared for the examination. The results were declared on 24/2/2005 and 83 candidates were successful in the written examination. Due to the pendency of the litigation, interviews could not be held immediately. A committee of 5 judges was constituted for interviewing the candidates and interviews were held in March 2006. Thereafter, the marks obtained by 83 candidates in the written examination and in the interview were aggregated and the consolidated merit list of the 83 candidates was prepared in the order of the merit on the basis of aggregate marks. It contained the registration number, the name of the candidates, reservation category, marks secured in the written examination out of 100 marks, marks secured in the interview out of 25 marks, and the total marks secured in the written examination and interview out of 125. Thereafter, 5 more merits list in respect of categories BCA, BCB, BCD. Committee finalized the following list of candidates to be recommended for appointment as per merit and reservation and submitted to the administrative committee with a report dated 3/4/2006. Now, para number 8, Lordship. The full court considered the resolution of administrative committee dated 30/11/2004 and 4/4/2006 and the record of selection. The full court impliedly approved the resolution dated 30/11/2004, but it did not agree with the selection list prepared by the interview committee and approved by the administrative committee by resolution dated 4/4/2006. The full court authorized the Chief Justice to constitute a committee of judges for preparing a fresh list of candidates to be recommended for appointment of district and session judges. Accordingly, the Chief Justice appointed a subcommittee of 2 judges on 7/4/2006. The said subcommittee was of the view that the candidates should be evaluated with the reference to written examination, marks of 75, interviews marks of 25 as per the resolution dated 30/11/2004, instead of being evaluated with the reference to written examination, marks of 100 and interviews of 25, thereby varying the prescribed ratio between written examination marks and interview marks from 3:1 to 4:1. Therefore, it scaled down the marks obtained by the candidates in the written examination with reference to a total of 100 in proportion to a maximum marks of 75. By adding the interview marks of 25, the total marks obtained by candidates with reference
Go ahead.
Yes.
to a total of 100 were recalculated. The subcommittee was also of the view that apart from applying the minimum marks for the written examination for determining the eligibility of the candidates to appear in interview, the same cutoff percentage should be applied for interview marks. And those who fail to secure such minimum marks in the interview should be considered as having failed. As the minimum percentage for passing the written examination was 50% for open category, 40% for backward classes and 35% for ST/SC, only those candidates who secured minimum of 12.5 marks, 10 marks, 8.75 marks, were considered as having succeeded in the interview. Consequently, only 31 candidates were found to have qualified both in written examination and interview, and a revised merit list was prepared, pruned down to 31 successful candidates. On that basis, 9 candidates were recommended for appointment as under. One vacancy relating to scheduled caste women was left unfilled as there was no qualified candidate. The said report and the selection list was considered by the full court on 28/4/2006, and it was resolved to accept the names of the aforesaid 9 candidates in the said list to the state government for appointment. The second list contains the names of 5 out of 10 candidates recommended in the first list, 2, 4, 6, 8, 10 in the first list, 1, 3, 4, 7, 9 in second list, and 5 candidates in the first list, 1, 3, 5, 7, and 9 in the first list got eliminated as they failed to secure the minimum marks in the interview, and 4 fresh candidates entered in the second list. No candidate was selected under the category of SC women, as no candidate for that category secured the minimum marks in the interview. 2 of the candidates whose name were found in the first list and who got excluded in the second list, namely K. Manjushri, filed writ petition 10061 and 10062 of 2006 in High Court, praying for a declaration that the action of the High Court in preparing the selection list by prescribing minimum qualifying marks for the interview was arbitrary and illegal, seeking a direction to the High Court to withdraw the selection list without adopting minimum qualifying marks for the interview. The said writ petitions were dismissed by the High Court by a common judgment dated 30/10/2006. This appeal is by K. Manjushri, whose name was found in the first list. She contended that the minimum marks.
You can skip all that contention. The issues we can
17.
go to paragraph
17. I'll just read 17. Issues are on the contingents urged the following questions arise for consideration. What was the procedure, method and manner of selection prescribed by the administrative committee for filling the post advertised on 28/5/2004, whether the list prepared by the interview committee and approved by the administrative committee suffered from any error, irregularity and illegality. Third point, whether the procedure adopted by the full court in preparing the fresh selection list by applying the requirement of minimum marks for interview also is legal and valid. The rules did not prescribe any procedure for selection. When the posts were advertised, the only criteria for selection that was mentioned was that the selection will be done by holding written.
Question 1, you can go straight to question 3, I think.
Here.
Right, question 3.
Yes, Lordship.
That you will get it.
It's important, the manner of holding written examinations and interviews. The marks for written examination and interview, whether the candidate should secure any minimum marks in the written examination or interview, were all yet to be decided. As per the practice followed by the High Court, the entire process of recruitment of district judge was to be dealt with the administrative committee, and the decision of the administrative committee were placed before the full court for its consideration and approval. The administrative committee at its meeting held on 30/11/2004 considered the method and manner of recruitment to the adopted in regard to the said recruitment and took the following 3 decisions: that the written examination will be held on 31/2005 simultaneously at 4 centers, that the marks for the written examination shall be 75 and for oral examination 25, that the minimum qualifying marks for OC, BC, SC and ST shall be prescribed earlier. The 2 decisions are self-contained and clear. In regard to the third decision, it becomes necessary to ascertain what were the minimum qualifying marks for OC, BC, SC and ST, which had been prescribed earlier. There were no general prescription of guidelines or norms or criteria for holding the written examination and interviews marks, therefore. The procedure to be applied in regard to each recruitment was laid down separately by the administrative committee as and when the recruitment was done. When the administrative committee decided on 30/11/2004 that the minimum qualifying marks for OC, BC, SC and ST shall be prescribed earlier, it obviously referred to what was prescribed when the previous recruitment was made in 2001 and 2. The High Court has produced the relevant minutes relating to earlier recruitment. It is seen that the administrative committee had laid down the following method and manner for recruitment to 6 posts of district and session judge. Its resolution dated 24/7/2001. Considered and resolved that the mode of examination be by way of written test for 75 marks and oral 25 marks, and the minimum qualifying marks for open categories 50 marks and for other categories of 40 marks and 35 marks. Written examination in the same ratio will be applied for the oral interview also. The minimum qualifying marks for the written examination was subsequently amended, corrected by administrative committee at its meeting held on 21/2/2002 as follows. Considered and resolved to correct the typographical error occurred in the resolution of administrative committee meeting held on 24/7/2001 mentioning 50 marks, 40 marks and 35 marks instead of 50%, 40% and 35%. That is the minimum qualifying marks for open category is 50% for backward, 40% and scheduled tribe, 35% in the written examination. Let us to try to analyze and find out the combined effect of the resolution 24/7/2001, 21/2/2002. The resolution dated 24/7/2001 prescribed the following marks for the written examination and the interview. The marks for the written examination was 75 marks and the minimum qualifying marks was 50 marks for open category, 40 marks for the backward classes and 35 marks for scheduled tribes.
Twenty-five and 27.
25, Lordship. 25, I will now read, Lordship. When the administrative committee placed a merit list and selection list before the full court, apparently objections were raised on two grounds. One related to failure to provide the minimum 50%, 40% and 35% marks for interviews on the interpretation of resolution dated 30/11/2004, read with earlier resolutions dated 24/7/2001 and 2002. The second objection was that even though the administrative committee had resolved that the marks for written examination should be 75 and interviews would be 25 at the time of tabulating the marks secured out of 100 marks in the written examination had been taken into account without scaling it down with the reference to a maximum of 75 marks. The full court therefore appointed a subcommittee of 2 judges to examine the matter and prepare a fresh merit list and selection list. The subcommittee examined the matter and submitted a revised merit list by incorporating 2 changes. Firstly, while tabulating the marks, it scaled down the marks secured by the candidates in the written examination with reference to a maximum of 100 marks in proportion to a maximum of 75 marks, so that the final marks were with the reference to a base of 75 marks for written examination and 25 marks for interview as resolved on 30/11/2004. Secondly, it applied the minimum percentage of 50%, 40%, 35% for OC, BC, SC and ST even in regard to interviews, and consequently eliminated those who secured less than minimum in the interview. From the process of selection, the panel selection list was prepared with a reference to the fresh merit list prepared by incorporating the said 2 changes. As far as the first change is concerned, we have already held that a scaling down is unexceptional as it is consistent with the criteria decided by the administrative committee on 30/11/2004 before commencing the selection process. But what could not have been done was the second change by introduction of the criteria of minimum marks for the interview. The minimum marks for interview had never been adopted by the Andhra Pradesh High Court. Earlier, for the selection of district and session judge, in regard to present selection, Administrative committee merely adopted the previous procedure in vogue. The previous procedure as stated above was to apply minimum marks only for written examination and not for the oral examination. We have referred to the proper interpretation of the earlier resolution dated 24/7/2001, 21/2/2002 and held that what was adopted on 30/11/2000 was only minimum marks for written examination and not for interviews. Therefore, introduction of the requirement of minimum marks for interview after the entire selection process was completed would amount to changing the rules of the game after the game was played, which is clearly impermissible. We are fortified in this view by several decisions of this court. It is sufficient to refer three of them: P.K. Ramchandran Iyer versus Union of India, Umeshan Shukla versus Union of India, and Durgacharan Mishra versus State of Orissa. In Ramchandra Iyer, this court was considering the validity of a selection process under the ICAR Rules 1977, which provided for minimum marks only in the written examination and did not envisage obtaining a minimum marks in the interview. But the recruitment board prescribed a further qualification of obtaining minimum marks in the interview also. This court observed that the power to prescribe minimum marks in the interview should be explicit and cannot be read by implication for the obvious reason that such deviation from the rules is likely to cause irreparable and irreversible harm. This court held that as there was no power under the rules for the selection board to prescribe the additional qualification of securing minimum marks in the interview, the restriction was impermissible and a direct impact on the merit list, because the merit list was to be prepared according to the aggregate marks obtained by the candidates at written test and interview. Once an additional qualification of obtaining minimum marks at the Viva Voice test is added to candidate who may figure high up the merit list was likely to be rejected on the ground that he has not obtained minimum qualifying marks at the Viva Voice test. To illustrate, candidate who has obtained 400 marks at the written test and obtained 38 marks at the Viva Voice test, it considered on the aggregate of marks being 438 was likely to come within the zone of selection, but what would be eliminated by ASRB on the ground that he has not obtained qualifying marks at Viva Voice test. This was the impermissible and contrary to rules, and the merit list prepared in the contravention of rules cannot be sustained. In Umesh Chandra, the score of Delhi Judicial Services Rules 1970 came up for the consideration. The rules provided those who secured the prescribed minimum qualifying marks in the written examination will be called for Viva Voice, and that the marks obtained in the Viva Voice shall be added to the marks obtained in the written test, and candidates' ranking shall depend on the aggregate of both. 27 candidates were found eligible for appear for a Viva Voice on the basis of their having secured the minimum prescribed marks in the written examination. The final list was therefore expected to be prepared by merely adding a Viva Voice marks to be written examination marks in regard to those 27 candidates. But the final list that was prepared contained some new names which were not in the list of 27 candidates who passed the written examination. Some names were omitted from the list of 27 candidates who passed the written examination. It was found that the selection committee had moderated the written examination marks by addition of 2% for all candidates, as a result of which candidates who did not get through the written examination became eligible for Viva Voice and came into the list. Secondly, the selection committee prescribed for selection and a minimum aggregate of 600 marks in the written examination and Viva Voice, which was not provided in the rules, and that resulted some of the names in the list of 27 candidates being omitted. This court held neither was permissible dealing with the prescription of minimum 600 marks in the aggregate the court observed. There is no power reserved under Rule 18 of the rules for the High Court to fix its own minimum marks in order to include candidates in the final list. It is stated in para 7 of the counter affidavit filed in writ petition that the selection committee has inherent power to select candidates who, according to it, are suitable for appointment by prescribing minimum marks.
Can certainly
33 actually, because then he refers to one more judgment and then goes to para 33.
Lordship, 32 also.
All right.
In Maharashtra, SRTC and Rajendra Bhimrao Mandve, this court observed that the rules of the game, meaning by thereby that the criteria for the selection cannot be altered by the authorities concerned in the middle or after the process of selection has commenced. In this case, the position is much more serious. Here, not only the rules of the game were changed, but they were changed after the game had been played and the results of the game were being awaited. That is unacceptable and impermissible. In 2004, merely adopted the procedure prescribed earlier. The previous procedure was not to have any minimum marks for interview. Therefore, extending the minimum marks prescribed for written examination to interviews in the selection process is impermissible. We may clarify that the prescription of minimum marks for any interview is not illegal. We have no doubt that the authority making rules regulating the selection can prescribe by rules the minimum marks both for written examination and interviews, or prescribe minimum marks for written examination but not for interview, or may not prescribe any minimum marks for either written examination or interview. Where the rules do not prescribe any procedure, the selection committee may also prescribe the minimum marks as stated above. But if the selection committee wants to prescribe minimum marks for interview, it should do so before the commencement of the selection process. If the selection committee prescribe minimum marks only for written examination before the commencement of selection process, it cannot either during the selection process or after the selection process add an additional requirement that the candidates should also secure minimum marks in the interview. What we have found to be illegal
Now seen,
We'll come back.
we'll come back after lunch. After this, we will look at Marwa, and then you can make your submissions on it. And then we'll hear what all of you have to say.